Hello, I'm carrying on with freehold covenants. So, looking at how burdens can be passed at law as opposed to in equity. So, the burden of a covenant cannot pass at law to become directly enforceable against those who are successors entitled to the covenanter. Osterbury and Oldham Corporation 1885 is a key case about this one, and the Court of Appeal said that the contractual rule is applicable here, that only a party to a contract can be burdened thereby. And this was upheld by the House of Lords in Rohn and Stevens 1994. So the rule is there because we need to stop land being fettered forever and reasonably, and that would prove a real detriment and, well, there's no other alternative, forgive the double entendre, burden to the future successors entitled. But some people have criticised this fiercely. Now, there are devices to get around this, such as transferring the land on a long lease, which can be turned into freehold, and thereby using the law of leasehold covenants. There can be common hold arrangements. So that's maybe, say, a building divided into lots of flats. I have a common hold arrangement, and each individual flat is also owned by somebody else, but they all co-own the whole lot. There can be restrictive covenants on that, such as you can't divide your flat. Okay, you could create a conditional fee symbol subject to the right of re-entry. You could set up a chain of indemnity clauses, or you could use the doctrine of mutual benefit and burden. Okay, that's where there's mutuality to the benefits and burdens between all the parties concerned. So of these methods for direct or indirect enforcement of covenant, the most scintillating is surely that doctrine of mutual benefit and burden, or people sometimes call it the doctrine of Halsell and Brizzle from the 1957 case. So in that case, a person who claims a benefit for conveyance, such as the right to use a road or drain or something, is also subject to the burdens, as in he will have a concomitant obligation to pay towards the costs of keeping it in good repair. So Lord Templeman in Rohn and Stevens 1904, he said that this doctrine was not applicable to that factual case, but nevertheless he upheld the principle, and he said there are certain restrictions on its operation. So a number of cases have delved into these quite deeply, such as Thamesmead Town Limited against Alotti 1998, or Davis and Jones 2009, Wilkinson and Curdine Limited 2013. So there are three criteria which need to be fulfilled for this principle to be invoked successfully. 1. The benefit and burden have to be conferred through the same transaction. This is usually a conveyance or another deed, but it's got to be at the same time in the same document. 2. The substance of benefit and burden must be connected in as much as the former is conditional on reciprocal to the latter. Okay, so the benefit is conditional on the burden or related to the burden. 3. A person who's subject to the burden must be able to reject it or disclaim it. So this principle is inapplicable where the burdened owner has no benefits. It means that a seller, by reserving some control over an essential facility, is able to enforce positive covenants which are linked with that facility against the purchaser's successors in title. But dissimilar to restrictive covenants, which create an interest in the burdened land, the doctrine only generates a personal right to enforce a positive covenant, and that was found in Goodman and Elwood 2013. So many people foresaw the introduction of common hold, a new type of land holding, would be advantageous. It would be a way to circumvent these hurdles created by the ruling in Rohn and Stevens. So the Common Hold and Leasehold Reform Act took place in 2002, took effect in 2004, and that brought in common hold. So this was a new scheme, so individual units within a property could be owned freehold rather than leasehold, as I adumbrated here and before. But the management of the land is subject to a scheme and can be conducted as a whole, so the whole block of flats or whatever it is. So a new block of flats could be managed by a common hold association, and each flat is owned individually. The reciprocal positive covenants which help people to enforce the rules of the collective and therefore to manage the different areas of the building. So the particulars of this scheme are highly complex. Anyway, common hold has not spread very far. So not that many schemes have been created since it was set up, like something like 30. So far, it's not alleviated the impact of Rohn's prohibition on the ban on enforcing positive covenants against successors entitled to burdened land. Now, that might change because the Law Commission has produced a report on common hold, saying it's a preferred alternative to leasehold ownership. They wrote a report called Reinvigorating Common Hold, a preferred alternative to leasehold ownership. Anyway, that came out in 2020. In January 2021, the government said it set up a common hold council as a partnership of leasehold groups, the property sector and the government, and they are going to prepare homeowners in the market for a major shake-up of common hold, hoping it will spread a lot more. But anyway, we shall see how that pans out. So in the last analysis, you've got to remember the original covenanter is liable for performance of the covenant after transferring the servient land to a third party. But there are some remedies available against the original covenanter if, in this situation, these remedies are not many and they're difficult to come by. For instance, but even though a covenantee could claim damages in the covenanter for breach of covenant, he cannot stop the covenanter's successor entitled from using the servient land in a manner that goes against the covenant. All right, so let's look now at another thing, passing the burden in equity. So we know that the harshness of law is mitigated by the mildness of equity and its flexibility. There's that common law rule that burdens will not run with the land. Anyway, equity stepped in here. So because of equity, restrictive covenants are a worthwhile thing for the owner of the dominant land. So look at Lord Cottenham in Tulk and Moxie, that celebrated case from 1848. If equity did not enforce a covenanter's promise, it would be impossible for the owner of the land to sell part of it without incurring the risk of rendering what he retains worthless. That's what Lord Cottenham said. After Tulk and Moxie, it's been well known that the burden will run in equity so long as five criteria are adhered to. 1, it's a negative covenant. 2, it touches and concerns the burden's land as per the Swift test. 3, it protects land which is kept by the covenantee. 4, it's intended to run with the land. And 5, the successor has notice of that covenant. So Hayward and Brunswick Permanent Benefit Building Society 1881 is a case in point. So there is not much to be gained by enforcing a burden of a positive covenant against the covenanter's successors in title. So Lord Templeman and Roland Stevens said that the truth of land law is this: positive covenants affecting freehold land are not directly enforceable except against the original covenantor. So Lord Templeman went on to say the following: equity cannot compel an owner to comply with a positive covenant entered into by his predecessors in title without flatly contradicting the common law rule that a person cannot be liable upon a contract unless he is a party to it. The enforcement of a positive covenant-lighted contract. A positive covenant compels an owner to exercise his rights. Enforcement of a negative covenant lies in property. A negative covenant deprives the owner of a right over a property. Close quotation. So anyway, there's no point in showing that a benefit of a positive covenant is passed on unless someone is burdened by it. It's worthless if no one's burdened by it. However, whether a covenant is positive or negative is an issue of substance. It's not an issue of form. A covenant to keep the land in a certain state is really a covenant not to build on it. So that means it's negative in substance. It doesn't require you to actually go and do something. It requires you to refrain from doing something. So about inaction, not action. Usually, if a covenant obliges a covenant to expend money or to do it, then that means it's a positive covenant and its burden does not run with the land. In Roland Stevens, the covenant was to keep a roof in a good state of repair. That's a positive covenant because it obliged someone to do something and quite probably to spend money. Therefore, the burden did not pass on to the buyer of the house. But that was bad news, really. The covenant was unenforceable after sale because it was a joint roof. So therefore, the owners could no longer ensure that their roof was going to be in a good state of repair. There's a problem in one half of the roof is going to spread to the other. Okay, in London County Council and Allen, 1914, there was a case that showed that easements, where there are two tenements, the covenant must benefit the dominant tenement. So even though both parties of the covenants are free to sell their land as they wish, the covenant is only enforceable so long as it benefits a piece of land which can be identified as the dominant tenement. Newton Aberative Cooperative Society Limited and Williamson and Treadgold Limited only the holder of the dominant land can sue to enforce this covenant. But bear in mind the landlord's reversion on the lease is enough of an interest for the purpose of this rule, and that can give the landlord, doesn't always give the landlord, the right to enforce a restrictive covenant against others, a sublessee, for instance, if the other requirements are satisfied, as per Hall and Ewan, 1887. So after 1925 covenants relating to covenanters' land, it was assumed that, as in this case, in the absence of intention to the contrary, as per Section 79 of the Law Property Act 1925. So look at Morals of Oxford Limited against Oxford United Football Club. Morals of Oxford being a brewery. Here, this requirement was not fulfilled. A person sold part of his land as a public house and covenant not to allow any competing business to be established on the land he was keeping. The Court of Appeal found this covenant was personal nature and was not intended to bind the covenanter's successors in title. So remember, the covenanter's successors in title must have notice of the covenant. It's vital to remember that freehold restrictive covenants are there, entered into since 1925, have to be protected in order to be binding upon the covenanter's successors in title. And therefore, in registered land, after the Land Registration Act 2002, it has to be protected by entry for notice. In unregistered land, these covenants are registrable as Class D2 land charges on the Land Charges Register. Remember the Land Charges Act 1972. An equitable interested land, a restrictive covenant entered into prior to 1926, is still subject to the doctrine of notice. Okay, so that's enough at the moment. Bye.